Welcome to The Fine Print, a podcast where experts at Succession Resource Group unpack the latest industry trends, recommendations, and observations for independent advisors managing their practice with no fluff and hopefully a little entertainment. In each episode, we'll discuss ways in which you can understand and leverage the value of your business, grow your business through M&A, but also through an optimized organizational structure. Improve and protect your business to create a sustainable enterprise that can hopefully outlast you. And lastly, preparing for your eventual retirement and how to maximize that result. We're not just tackling high-level concepts, hence the title. We're getting into the details, or the fine print. So, we encourage you to listen in with whatever beverage suits your preference, and let's get to the forefront of industry trends with a fresh perspective to help you achieve your long-term business goals. Welcome to another session. David Grau Jr. here, leading your session today to talk about a topic that is coming up more and more often as we've seen certainly the industry grow and evolve, just the individual advisors and their teams grow and evolve. And I know most of you listening to this, given the subject matter we talk about, building enterprise value, succession planning, mergers and acquisitions, these aren't necessarily topics for the small solo advisor at a wirehouse. So I suspect the subject matter today really should resonate with most of you, either where you are or aspirationally where you plan to be. And that is strategies to keep your top talent, but also make sure you keep your clients should one of your advisors lose his or her mind and leave. So, as firms grow and evolve over time, from solos really initially, to eventually maybe silos working together but separate, and then silos maybe morphing into an integrated ensemble team. Maybe they skip that step and then get right to the ensemble, but then some of these ensemble teams, they're actually growing into legitimate businesses and enterprises. And now we're seeing private equity investment and aggregators coming after it in a big way. As that evolution happens and you go from being the simple solo practitioner, lifestyle practice, lean, mean, super efficient, to the integrated ensemble of the enterprise, your team grows. As your team grows, those working with your clients expands, moves on beyond just you, and eventually you will have, if you don't already, clients who you don't even know. So, that is the jumping off point for the conversation here today. How do we make sure that you protect your most valuable asset? Well, what exactly is the most valuable asset? Aside from your team, I would say your clients are your most valuable asset. But I put it in that order, and I do it on purpose. I'm a firm believer of, I think, Richard Branson's perspective on this, or at least a quote of his that I love. And that quote is, clients do not come first. Employees come first. If you take care of your employees, they will take care of the clients. I couldn't agree more. So, if we start with the premise for our podcast here today that your employees are valuable, your clients are valuable, what can we do to protect both? I want to tackle this in two major segments. Positive segment, the carrot. How do we make sure that your employees, your team members, your contractors, they just never want to leave? But then the stick, if they do leave for whatever reason, how do we make sure that your clients, your other most valuable asset, is protected? So let's start with the carrot. When I say the carrot, carrot and stick is a saying. Carrot is all about making sure your people want to be here, making sure that you have the ability to attract new talent. And how do we do that? It's going to sound obvious, but it's things like career tracks, having upward mobility in the organization. With career tracks generally comes pay bands. Nice to know in general, like how I go from being a paraplanner to a partner someday and what that compensation track might look like. Good to know. But then supporting that, because job descriptions and pay bands and career tracks are great, but we need a culture of mentorship. We need you as the founder, if you're listening to this today, focusing on training Gen 2. We need Gen 1, Gen 2, focusing on training Gen 3. we have that in place. We have a happy, healthy culture. I mean, it's not always going to be perfect. You're going to have some folks occasionally on performance improvement plans. I mean, it happens. But then beyond those things, some of the other carrots as tools to build in around the culture, because I can't sit here as a podcast and tell you how to have a great culture. It's going to be a different answer for each of us. And there's lots of great coaches and consultants out there that can help you with that stuff. One of the tools that we help folks who have a happy, healthy culture, generally speaking, implement is things like an equity sharing program. A really good way to keep these people tied in is to give them a sense of ownership. And there's lots of different ways to do that. I say lots, there's not really that many, but more than most folks we talk to initially might otherwise expect. First cut at it on an equity sharing program is real equity or phantom equity, or some people synthetic equity, sixes, six of one, half dozen another. You got fake equity, phantom equity, synthetic equity that tracks with real equity. And then you have the actual equity. But under each of those categories, phantom equity plans, we do a lot of stock or equity appreciation rights, where it is a phantom equity plan. If they leave, it goes up in smoke, but it gives them a stake in the appreciation and the value of the organization that they're working at and contributing to, hopefully, increasing the value of. And then you've got real equity, but real equity doesn't have to be the same type of or level of equity in terms of its rights that you as the founder have. That's certainly an easy place to start, but it's also where a lot of folks get hung up, where they've had bad partnership experiences or they just don't want to have a partner. Well, depending on how the entity is set up, work we do, we can help establish certainly real equity that has voting, profits, and value rights. Those would be your big three for you as a founder. But you can start peeling some of those things off and creating second and third classes of ownership, depending on your structure, obviously. So you can get into things like liquidation rights. We do that a lot, where it is just a stake in the value of the organization. I mean, said more simply, if I granted you 1% liquidation rights in SRG, you would have 1% of the value of the organization. Now, again, is it taxable? Yeah, potentially, but we can control that taxation with vesting. So there's ways to control it. So you can do a real equity plan that has very limited rights, like just a stake in the value. You could do non-voting ownership, which has a stake in the value and a stake in the profits. You could even do profit interests, where there is really just a financial benefit. It's just a stake in the profits. Point being, you have options. And so it's worth understanding those options, because as the carrot, if you have a culture of mentoring and training, great employee benefits, or even just good employee benefits, plus a path to the top and a way to help get them there through maybe a phantom equity plan or some kind of other equity sharing program with the right protections for you to get it back, obviously. I mean, I wouldn't put that in the bleeding edge category for our industry, but it's still kind of leading edge. Like, there's not a lot of firms, big or small, who are doing all of these things. And so it really gives you a leg up on not only keeping your talent, but starting to pull other people's talent away, which can be another really great asset. Other simple one on the compensation side is things like a vested bonus program. It's good to write these things up and we can help you do it. But said more simply, if you were going to give your team, let's say, each a $12,000 bonus at the end of the year, company's done well, they've contributed, we're all happy, everything's copacetic. Going to give each of them a $12,000 bonus. As an option, we can put together a long-term incentive plan, for example, where we say, yes, you will get that bonus. We might even make the bonus a little more generous, might increase it a little bit, but it's going to vest over 3 years. So if you got a $12,000 bonus, you're going to get $4,000 the first year, and then you get $4,000 vested the second year. You get $4,000. You can do the math, obviously. But boy, if you were going to do that, or you have a track record of doing that, and we now increase it maybe a little bit, but we add the vesting component to it, if they ever contemplate leaving to take a better offer, at least just in a vacuum, if we look at that bonus program, they'll always be leaving year 2 and year 3 of the previous bonuses on the table. They're walking away from them because they haven't invested. So they can never really get off this hamster wheel. So there are lots of ways, even in just the carrot category, not even coming down with the stick yet, with the contracts and litigation, to make sure that you frankly never have to get there. So I love focusing more time and effort on the carrot. Generally, most folks are looking to make sure they protect their clients by jumping right to the stick, the solution. Like, how can I put a non-compete in place to make sure if they leave, they can't take my clients? That is important, and let's tackle that next. But also, how do we make sure we put things in place, invest in the business and the team so that that just doesn't happen, or it certainly doesn't happen very often? That is a worthwhile investment. Even if it seems like it costs you a lot, you'll never have the basis for comparison. But I think you could Google it, or I'll just tell you, litigation, arbitration, it doesn't matter which one, it is expensive. To the point where the Jews probably not worth the squeeze unless they left and took your entire book with them. So let's put the carrot to the side because that is important. It's an ongoing thing that we as employers all work around, struggle with, all trying to provide a happy, healthy, safe work environment that our people want to be in, virtually, remotely, or in person. Doesn't matter. Same thing. On the stick side, I will tell you my basis for analysis here. Not an attorney. We have an attorney here, but even so, they're still not your attorney. So you're going to want to seek either A, legal advice, or work with us and let your local attorney review it. Save a lot of time and money. But my basis for my recommendations here, or considerations at the very least, using the stick, is I've worked with clients all over the country. We've done the research around restrictive covenants, non-competes, non-solicits, from California to New York and everywhere in between. And I don't love doing it, but I've served as an expert at arbitration and litigation around these matters. So I sadly get a front row seat sometimes watching people fight over these things. I have seen what works. I have seen what doesn't work. I have seen what resonates, more importantly, with judges, with panels. That's what I want to share with you here today. So, again, best way to protect your clients from leaving is not with a contract. And I wouldn't even say it's necessarily, the stuff that I just talked about in the carrot category. It is, but it's more about the client experience. Firms historically, and some of you listening might be this way, firms historically have had advisors they bring on, and they are responsible for finding and serving their clients. They build a book of business. That's the expectation. I'll assign some clients to you, but then your job is to go out and find more. Well, unfortunately, in our business, your business, the client relationship is the equity. You can say you own 100% of the LLC or the S Corp. If you have an amazing team, you're acting as CEO, leader of the organization, and marginally client facing at this point. If you have team members that have been bringing clients on board, and then generally the sole point of contact for those clients, you can own the LLC. It does not matter. They own the relationship. The relationship is what has value. So do your best to institutionalize that relationship. And I mean that in a good way, in that if you had a first year client experience, client comes on board, they generally would obviously work with their lead advisor, the relationship manager, but they might interact with your insurance specialist. They might then at some point also the lead advisor will pull in the financial planning specialist to present the financial plan and then go away. They interact with your amazing support team. Basically, between the products, the services, and more importantly, the client experience, not the service model, that's a whole separate conversation, but the actual client experience. That is going to be your best way to make sure that if an advisor loses his or her mind, they leave or you terminate them. It happens. You work to make it so that following that exiting advisor that goes up and hangs his or her shingle out would seem crazy. There's no way that solo advisor could possibly do and deliver on the experience that you and your firm have created. That's going to be your best bet. But beyond that, and let's say you have all that in place, I still think it's important to have the stick. Let's make sure if we need it, we can pull it out. And that is contracts, employment contracts. So, couple of initial considerations here. Number one, real basic is if you're going to have an employment contract, whether we prepare it, because we've got great form contracts we've used over the years and then seen people fight over and refine them, or you got local employment attorney that does this for you. Who is the employer? Is it you as an individual? If you have an LLC or an S corp, is that the employer? Again, the obvious answer would be if you have an LLC or an S corp, it's probably going to be the entity, or at least it should be. If it's you as a sole proprietor, then set up an S corp or an LLC and have that be the employer, preferably. I acknowledge if you're listening, you're under an independent broker dealer, for example, or a corporate RIA, and you're an IAR getting paid out running your individual book of business. It can be tricky, but it can be done. At the same time, what you want to be careful of is if you put together an LLC, let's say, and I'll give you your most complicated scenario, you're under a corporate BD and RIA, independent, but still, the corporate BD and RIA. They're paying you out individually, and you're moving that money over compliantly with the IRS. You got the right documents in place that we helped you with, but you're getting all that money moved over to the LLC. What you have to be careful of is then paying out your team members on revenue splits. The last thing you want to do, or at least up there, the last things you want to do, is have an issue with FINRA in particular on having it viewed in any way, shape, or form that you are redistributing securities. Not a conversation you want to have. Also, GDC splits, not the best way to build a team-based environment, so I wouldn't do it anyway, but I have certainly seen folks, they've taken, let's say, their attorney's advice or parts of our advice that they've heard. They've got all the money flowing into the LLC or the S Corp. They're paying their team, the company's the employer, and they're paying them a 35% split of GDC. Terrible idea for so many reasons. So, also know that revenue splits, they're not a division of ownership. If I've got a team member and we're splitting revenue 50-50, that's splitting the revenue. The question still remains, who owns the client? Who controls what that split is? So initially, first cut in the employment agreement as we work to get these things set up is who is the employer? Should be the entity if you have one. If you don't, get one and then have it be the employer. Number two, who actually owns the clients? Like as you're setting the agreement up, that's an important thing to address. And it may not just be a purely analog option, like, well, the firm owns the clients. Well, do they? Because if an advisor joined you and they brought over, 50, 60 households, did you acknowledge when they came over that those are their clients? Because if you did, we should probably just carve that out. Say, well, no, I never made that promise. Or they came over and they didn't have any clients. Okay, well, what about like friends and family? If they left, would you let them take their mom and dad, the rich uncle, friend, roommate from college? I should hope so. Again, part of answering this question is also if you were sitting in front of a judge, an arbitrator, a panel, if it's FINRA, let's try to make sure you look like the reasonable one in the room. If you come down as the employer dictator, especially in a liberal state, and you say, I own everything. I own your mom and dad's accounts and clients in the relationship. You own nothing. Good luck. So initially, who owns the clients? That is an important distinction. And it's not crazy that you might bifurcate and create, one, two, maybe three different client groupings. There's the clients you assign to them, for example. They clearly would not own those. Maybe after some period of time, you might give them the ability to have some claim to a small portion of equity. Maybe. But that's bucket one. You have clients that they bring over. That's bucket two, assuming that they came and joined you with clients. Not uncommon, you would carve those out. Those are theirs. They can take and leave them. Sucks, but it is what it is. And then you got the friends and family. Those would be ones that pretty universally the employee owns. We will acknowledge that. So you got those three different buckets as an example. And so it's common to acknowledge ownership in certain segments, but not all. Trouble is, I see a lot of employment contracts from folks who are coming on as prospective clients that it doesn't speak to the ownership of the client specifically really at all. I mean, kind of indirectly, as in you're an employee, but it doesn't actually address it, let alone other industry specifics. And then if they do own clients, even if it's just friends and family, be sure to address the what if scenarios. If you say on paper, you employee own the clients you brought, your friends and family, what happens if they die or become disabled? You said they own it, but you're probably going to keep those clients, or at least that would be the hope or expectation. Therefore, we probably need to make sure in that agreement we build in some contingency terms, which fortunately we just did a podcast on contingency. So if you want to unpack any more about that subject, you can listen to the other podcast. You can also Google it. There's good resources out there, resources on our site. But if you say they own something, let's make sure we have the ability to keep it in the family, in the company, but we need to address it. If they don't own anything, that's fine. That happens, but let's be very clear about that. You were an intern, and then you were hired full time. You were trained. You were mentored. You rode second chair for years. Now you're being assigned a book of business to service. Like, you do not own it. We have spent considerable time and money on both you and cultivating these clients. You will get paid fairly, but you do not own them. Write that down. Make it abundantly clear. Again, we'll help you with these things, but if you work with local counsel, we want to write that down. And then you get into the quintessential stick component here, and that is restrictive covenants, and what everybody would assume we're talking about, which is non-competes, which is such a ball of wax to start to untangle and unravel. When you think about things like, you've got the FTC here recently in April issued, at the federal level, a ban. I think it was like a 3-2 vote. You've got California, for all its glory, has Senate Bill 699 and the Assembly Bill 1076, I think it was. Basically, 2 bills in California earlier this year that, frankly, went beyond what we already knew, which was these things weren't enforceable, and started to build some penalties in for having them. So the writing's on the wall. And also, by the way, a non-compete, which I will unpack for you here momentarily, it's on my agenda of things to make sure we address together. A non-compete is not the thing you need. I get why they're being banned. So let's talk about those. So when you say restrictive covenants, or when we say restrictive covenants, there's like 4 or 5 different layers to this. So you've got things like, trade secrets and confidentiality. If they leave, they can't take that intellectual capital. That generally, from the attorneys that I have talked to, work with, our internal counsel, and frankly, the cases that I've been involved with, that one seems, as long as you take steps to protect your intellectual capital, and if you're posting that shit online, good luck protecting it, but you take steps to protect it. Therefore, you can protect that. So that is protectable. But then you get into the things most people think about, like the non-compete agreement. You got the non-compete, non-solicit, maybe a no-serve or no-accept, and then those confidentiality or trade secrets. Like, those are your big ones, generally speaking. So let's bifurcate. Let's split each of these out. You've got a non-compete. A non-compete is as it sounds. It is us as an employer telling an employee, you cannot exist in the financial services industry in a fill in the blank, a 25-mile radius of the company's office. You can't be a bank teller. You cannot be an advisor. You cannot earn a living in this industry inside what we've designated as our safe zone. So that's the non-compete. You got non-solicitation or non-solicit agreement. That is, if you just had the non-solicit, instead of creating a fence around an area that you can't exist within, we don't care where you exist. You just can't solicit, as in like ask for business from our clients. I don't care if you go to Antarctica and do it. You can't ask for business from our clients, wherever. So there's generally, it's not geographically limited, but it is more limited to our clients. If you want to go across the street and start your own business and start attracting your own clients, non-solicit, no issues. And then you have the no serve, or sometimes referred to as a non-accept or no accept. The problem with a non-solicit is you have folks who leave an employer or a wirehouse, for example, and they have an ironclad non-solicit and non-compete. And then they go across the street, and a year later, they have most of their clients. Well, it's because in a relationship driven business, I don't have to solicit the clients. Even broker protocol aside, which I'll talk more about in a second, I don't even have to follow broker protocol necessarily. If my clients, if I just tell them name and address of how to contact me, and then I'm leaving the firm, there's ways that your attorney can help you articulate that more clearly. But because you have the relationship, I don't have to ask anybody for any business. They'll follow me. So the way you get around that then is that no serve or no accept, where we say, I don't care who solicited who. If you leave, you cannot do business with our clients. You can go get your own clients, knock yourself out. But you can't do business with ours. Our clients, as it turns out, are ours. So that's the non-compete, or that's the no serve and the non-accept. The trouble with that one is if you are an RIA, that can work. You can't accept business from the firm clients, go get your own. If you're under FINRA, you got Rule 2140 to contend with, which is the same thing that broker-dealers have to contend with, which is we can't stop a client from moving and wanting to work with a different advisor, different firm. So it makes it a little tricky. And then on top of all of these things, you have okay, so what? What if I do compete? What if I do solicit? What if I do business with the firm clients? Then you have liquidated damages, which is if you breach, here's how we're going to get to a number. You're going to pay X times the revenue from the client you took. You see that a lot. Trouble is, I oftentimes see folks put these documents together and the attorney lacks context. And so they ask their attorney to put this in. They have a non-compete, non-solicit, maybe even a no-serve. And then they've got them paying 6 times revenue if the advisor leaves and takes clients. You want to avoid being punitive. We're not trying to punish here. We're trying to get fair value. So be reasonable. If you're going to have this, be reasonable. The problem is these things generally don't work. They certainly don't work in places like, California, but it's happening more and more, especially when you start seeing things like the FTC ban at the federal level. Like, they're expensive to litigate, even if they do work. Like, you know how you enforce these things. It is involving attorneys and judges. And I know it's a little cliche, but legitimately the only people who win there are the attorneys and maybe the judge because you keep him or her employed. Even when you win, I mean, it will be an emotional victory, I promise. I've talked to a lot of folks that have been through this, but it is not a financial victory, generally speaking. You might break even. In fact, in many cases, you very well may know you're going to lose money on this, but as you have a growing team, growing business, you must establish a very clear precedent. You will go to the mat for this. So I get it. But there's better options, even when we are talking about the stick and protecting and using contracts. So my recommendation here is do away with the non-compete, the non-solicitation, the no-serve, the no-accept, the liquidated damages, put all that aside. It will also make it really hard for you to recruit and attract good talent when you have all of that stuff baked into an employment contract. Because most employment contracts that we'll produce are probably, 8 to 12 pages. They're 8 pages, give or take, if you don't have this stuff baked in. They're 12 pages if you do. Like, you end up with a lot of bulk of very scary stuff for an employee coming over and joining your team that they're going to feel compelled to go talk to an attorney for, which they should technically do anyway. But you're going to kind of force their hand to go get legal advice when they read this stuff, especially if it's got non-compete language. So just be reasonable. Number one, it will help you more easily attract, recruit, and retain, but also enforce should you ever need to do that. Key here is if an advisor leaves and they take clients, we just build in buyout terms. CPA firms, law firms, and I've known and talked to lots of folks. They've been doing this stuff for decades, it seems. Kind of new to us, but not new to professional service businesses. If they leave, they take clients, they just pay for them. And we go a step further in our documents. Number one, to include a reasonable buyout multiple. And I would recommend we give them 2 years to pay it off if they leave and take clients. They leave, they take clients, they take $100,000 in fee revenue. We have a 3 times multiple. They're going to agree to pay $300,000, and I'll let them pay it over 2 years. So 150 first year, 150 second year. Play that out. Number one, you are very unlikely to end up in front of a judge and having to pay attorneys because A, you talked about it at the very outset of the relationship, and B, it's reasonable. That way, instead of that employee quitting, giving notice, and sneaking out the back door Friday night with their client files, they leave Monday afternoon after an albeit awkward lunch with you, but we all act like adults. We have the conversation, we know the procedures, and it's fair. Now, if you had to go enforce that, you're sitting in front of a judge or a panel, if it's FINRA, and you have a reasonable multiple that, if you called me as an expert, I could come support, or any number of other people could come support. You could support it with a Google search, even better. And you can show them not only is it a reasonable value if they leave and take clients that the firm owns, that they acknowledged the firm owns, but you'll also finance it for 2 years. It almost looks like you're promoting entrepreneurship, where you're saying, if you leave and you want to go start your own shop, I'll let you take our clients and I'll even finance it for you. The point is to appear to be the reasonable one. And frankly, if you do that, it's very unlikely you're ever even going to have to sit in front of a judge, which is a win. But you've got to establish a process. You've got to make it fair. And if you do, it will save time. It will save money. Other considerations, beyond the restrictive covenants, which I've spent a couple of minutes now talking about, is things like broker protocol. Again, if you're an RIA, not super critical, more than likely, because you're not doing a ton of recruiting, you're not probably part of it. But a lot of the folks, a lot of you listening to our off-script podcast, you are part of a large independent broker-dealer or corporate RIA. They are part of broker protocol. And so if you have an employee who leaves, they follow broker protocol, they don't want to pay you. The clients will follow them. Well, it's important to make sure, number one, we understand that if you are affiliated with a large broker-dealer, large RIA that is part of broker protocol, but you are an independent contractor, you are not by default part of broker protocol. We make sure we write it into the contract. The employment contract very explicitly lays out, we acknowledge broker protocols out there. These are the rules we all agree to play by. In broker protocol, if you actually go read it, it's the low bar. I mean, there are securities experts that can give you much better and more informed opinions on this. So keep in mind, you're getting it from the layperson, but we deal with this stuff a lot. And we see it at litigation and arbitration. And so go read broker protocol. I mean, it is intentionally the low bar. If you don't agree to something else as a team, this is what we've all agreed to follow, so we don't all end up suing each other into oblivion. We'll just write something else down. Acknowledge that it's out there and that we all collectively acknowledge we have raised the bar. We're not following broker protocol. But if you don't say it, it could be on the table. So also understand the level of enforceability for these things. Like when you talk about restrictive covenants, I'll just say generically, but again, that covering things like the trade secrets, confidentiality, the non-compete, the non-solicit, the no serve or no accept. Restrictive covenants really addresses some or all of those as a genre. When you think about it from an enforceability perspective, break it down into employer-employee, contractors, and then partners, owners. When we talk about the enforceability and the two California bills as a recent example to point to, but even I think maybe more recently, the FTC ban on non-competes, like those are employer-employee. Like go read them. It's very, very clear and very, very specific. And there are carve-outs for things like mergers and acquisitions if you're buying a business. Well, if you are a partner, as in, let's say we go back to our beginning of this podcast where I talked about maybe using the carrot and doing some equity sharing. If I gave my employee or they bought 1%, 2%, non-voting interest, voting interest, I don't care what the flavor is, they bought an interest in the business, well, they're now governed by partnership law and the rules of your operating agreement or your shareholder agreement. Totally different area in levels of enforceability. So it's good to break those things down. Again, if you want a more explicit answer, you can talk to your local legal counsel. Or again, you can always engage with us and we'll help you figure these things out. But it is an important distinction to draw that if you want something that you know is going to be enforceable, I mean, number one, being reasonable with things like the buyout and skipping past the non-compete, non-solicit, and all that nonsense. It's a good first step. But also make them an owner of some shape or size. And that can be a really good way to get yourself out of the employee-employer conversation altogether. I mean, it has other complications that comes with having junior partners. But if you're on that road anyway, in terms of like career tracks, and you've got some people that you would consider for that, that can be a really easy solution. So that's enough in terms of the carrot and the stick. It just is worth acknowledging that there is both. I would put more weight, more emphasis, and also just takes more time on the carrot side of things. Part of it we can help you with, things like the phantom equity plans, real equity plans. But then we eventually have to revisit the stick, and we hope we never need to use it, kind of like life insurance, but it is great to have it and never need it. Then the alternative, if you do this right, yes, you're going to want to make sure you get support on it. You're going to make sure you get good legal counsel, even if you work with us. We'll make it super turnkey on the phantom equity plan or the employment contracts. But you're still going to want to talk to local legal counsel after we get all that done so they can put eyes on it. Frankly, if nothing else, on the off chance you ever have to go enforce this, you're going to want somebody, boots on the ground, local, that can be there to help you support this. But whether you pay us on a flat fee basis or you decide to go it alone and have local counsel do it, this whole genre, the carrot and the stick, the phantom equity plans, the real equity sharing plans, building the culture, the career tracks. I mean, as much fun as that stuff is Monday through Friday, or even the employment contracts and working with us, working with the council, that is not an expense. View it as an investment. It's one of those investments that it's hard to quantify, because if you do this stuff right, you'll never actually have to go fight about it in front of a judge or a panel to really understand the true cost. But if if you're at a FPA chapter meeting, NAPFA meeting, one of broker-dealer, custodian meetings, a third-party asset manager meeting, talk to some of your peers. Somebody in that room will probably have dealt with a litigation matter related to employment and somebody leaving. I mean, it happens, unfortunately, a lot. That can give you some perspective. Like it can get obscenely expensive, like more expensive than you'd really think possible for the issue that you're tackling. So view it as an investment, and hopefully you'll never actually have to incur those costs or the stress related to it. And again, as you continue to grow your enterprise, that requires people. You can do your best to build the career tracks, mentorship, the happy, healthy culture. But, just like, a basketball team or any other sports team, like you won't always end up with the right player in the right seat at the right time. It happens even in a great firm with a great culture that you get folks who just, you're not aligned, you're not rowing in the right direction or the same direction. It happens. Tackle the carrot, tackle the stick, and you'll be in a much better place. And you can hopefully rest easy knowing as you grow and scale your team, your most valuable assets, your team and your clients, are protected. So I'll leave you with that. Good luck. Happy hunting. And that concludes another episode of The Fine Print from SRG. We hope you found this episode both interesting and valuable. We encourage you to check out our website at www.successionresource.com. And of course, connect with us on social media for the latest happenings here at SRG. If you just can't get enough of The Fine Print, we invite you to join our monthly webinar series and newsletters where we address many of the topics covered in this podcast in greater detail. Finally, if you enjoyed today's episode as much as we did recording it, please leave us a review, a good one, mind you, and tell your industry friends about us. Your support helps us continue to bring you the best content possible. The information covered and posted represents the views and opinions of the guests or individual hosts, and not necessarily the views or opinions of Succession Resource Group. Content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional advice, as amazing it might be. Always seek the advice of an expert with any questions you may have. As always, we at SRG stand ready to help when you're ready.